We'll look at the scenario now where we introduce the settlor into the mix, because obviously the preponderance of Singapore trusts will be reserve powers. And so we will have another fiduciary or otherwise sitting alongside the trustee. So we'll have a power holder that's not a trustee sitting alongside on the trust. And in this case, we'll assume that this is the settlor. So here's the headline questions that will be likely being asked is this: as a settlor with reserved investment powers, what are my obligations? What should I be doing? If we are going through COVID-19 and there are wide sort of fluctuations in investment returns, what should I be doing to manage this situation, given that I have the investment powers? The second aspect is, what is my liability for investment losses if for some reason I maladminister the exercise of these powers and cause even worse loss to the trust fund than was otherwise going to be the case? So these are topical issues because we have a majority of trusts, I suspect, in Singapore where we do have reserve powers that are either vested with settlors or have moved on and are with protectors or protector committees. So the question is quite relevant. So looking at the relationship between the beneficiaries and a power holder, in this case a reserve, settlor reserve power. The position under the Singapore Trustee Act, as we all know, is Section 95, which is declaratory, that basically sets out that having a reserved investment power does not effectively invalidate the trust. So you can't effectively claim that a Singapore trust is a sham by basis of the settlor has reserved an investment power or administrative powers. The critical question for us, though, is what is the nature of the power that's been retained by the settlor? This is critical because it then informs what obligations the settlor should be discharging, and then on the back end of that, what liability exposure the settlor could be potentially being suffered. So the Singapore Trustee Act doesn't set out the quality of a reserved power. It says that you can't invalidate a Singapore trust just by virtue of having a reserved power, but it doesn't go on to then spell out what the nature of that power is. So the question I'm asking the sort of panelists here is, in the mix of circumstances where a settlor is, let's say, not a beneficiary or is a beneficiary, or there is a settlor and then there's a protector committee that follows, or the settlor is just the first protector, in the mix of all of the different types of ways in which a settlor can be introduced as a power holder into a trust, what is the view on whether or not the settlor holds that power as a fiduciary, effectively as if he were a trustee, or holds it in a personal capacity so that he can basically ignore the power, not do anything about investment losses, and not be held liable for that? So those are the extremes here, and it's a very, very important question to answer because a lot of the settlors out there will be completely clueless as to what they should actually be doing in these circumstances. So I'd ask Victor to open us up on this one. When it comes to reserve powers, settlor reserve powers, does the settlor stand in a fiduciary standpoint, or does he hold this power as a personal power? And how do we figure this out?
Yeah, Zach, I think this is a really good question because I don't think much thought has been levied in this area. Yeah? And if you look at case law, and there's a very prominent case, right, of Lord Vestey's executors. There, it was a case involving the settlor's powers to direct investments. And Lord Simmons actually said that would be considered a fiduciary power, right? So I think that reserved settlor's power of investments would be considered a fiduciary power. Then the question is, would it be possible to change that into a personal power? And I think that arguably it could be, if express words are used, arguably.
I mean, do you see, in terms of, and I'm open to start to all of us at this point, do you see a difference between a settlor who's also a beneficiary or holds a power of revocation, as against a settlor who's excluded from the benefiting under the trust and is succeeded by a protector committee? So you actually have a semi-office holder rather than an individualized named individual. Do you see a difference in the potential interpretation of what's the quality of that power from a Singapore court standpoint? just ask Victor, just on the back of your answer on that.
Yeah, happy to. Now, I think the nature of the power should not change regardless of whether it's a settlor exercising the power or it's a protector committee. And in my view, it does not change whether the settlor is the main primary beneficiary or it's a mix of beneficiaries, right? I think the default position is that one is a fiduciary power, and that power has to be exercised in the best interest of all beneficiaries. I think if the settlor is perhaps the sole beneficiary during his lifetime, then in terms of proving a breach, that would be very difficult. But I don't think the nature of the power would change.
Okay. Tran, what's your view on this whole issue of fiduciary or personal when it comes to a settlor reserve power trust?
Yeah. I agree with Vic now. I think as a default rule, investment powers, are by nature likely to be regarded as fiduciary, right? As opposed to, for example, a power to add or remove a beneficiary, which the settlor may reserve to serve his own ends. So I start from that same viewpoint. One of the questions I think is when you decide whether to deal with it by putting in a clause to make it personal, for example, you can do that, or you can say that the settlor is not liable so long as he has acted in a good faith, right? So you set a low standard of care, and because in this case it's not a professional trustee. The settlor may have his own investment ideas. So you could make it personal. You can say you can invest. You can invest as you like. We purport to impose no standard. There may still be some room if you did something, not an investment at all, that it's outside the power, it's a fraud on the power, but you could do that. Or you could simply say that his duty is simply that of good faith. So, no negligence or gross negligence standard would apply to the settlor. So those are some options available.
Wenham, what say you on this point?
I agree with much of what Lian Chuan and Vigna said, but just to clarify or supplement, I think the investment powers in and of itself doesn't make the person making the investment decision a fiduciary. So for example, if there is a licensed fund manager and you appoint them to take care of the investment, I think that in itself doesn't automatically make the fund manager, especially a licensed fund manager, a fiduciary. So
Sure.
in this case, if it's a settlor, whether the settlor has the reserve powers or is succeeded by a protector committee, I agree with Vigna that nature doesn't change. The change of the label or the persona doesn't change the nature of the power.
Right.
But practically, I think there is a difference. So if it's a settlor and he's the sole beneficiary, I think in the earlier discussion, we said, you're not going to sue yourself. It's schizophrenic, right? So in most of the cases where we've handled in recent years where the settlor has reserved powers,
Yeah.
the settlor typically would be the patriarch or the matriarch and one of the beneficiaries. So again, so long as the patriarch and matriarch is alive, practically, I think the spouses and the children are not going to come out with a rebellion and start suing the matriarch or patriarch. So I think it's a theoretical issue while the settlor is still in power.
And then, Tony, from your perspective, from the trustee's perspective, the view that you take on settlor reserve powers is, are they automatically fiduciary, or do you come from a different standpoint on this?
I mean, generally speaking, a settlor is hardly ever just the only beneficiary. There'll always be other people. And as reserving investment powers, there's always an element of self-interest there. So we actually make those powers personal in the trustees. I mean, I think our view is that if they were fiduciary, that might actually even increase the trustees' responsibility to monitor another fiduciary within the structure.
Right. Okay, so if that being the case, the supplemental questions on this would be this: the liability exposure for a settlor, who we say is a fiduciary, they would import all of the duty of care, all of the issues that we've seen insofar as a fiduciary office holder is concerned. Ordinarily, we don't see liability clauses being used to protect settlor reserve or settlors that have reserve powers. I've not seen it as a systemized approach, that level of sophistication being brought to bear on the settlor's role in the trust. If it is the case that we have a fiduciary office by virtue of the settlor, then it must be even with more force that a paid professional protector would be definitely a fiduciary, particularly if the office were to be effectively perpetual insofar as the trust period was concerned. So the question I would ask is, if that being the case, if we have got, and for the benefit of the attendees who are professional trustees, if we have got a stock of trusts where the settlor is a reserve power holder, and we take the view that in these circumstances, they may well be in a fiduciary office. Question is, where are they getting any advice? What is being done to help them to understand what they need to do during this environment? And crucially, is it possible now for us to introduce an exclusion clause into the trust on their liability? I mean, that will undoubtedly come up as a question. Can we vary the trust to introduce an exclusion of liability if after the event we take the view that they actually are in a fiduciary position? So I'd ask Vitna to kick off on this one.
Zach,
Yeah.
you know, it's very difficult because if when you want to exercise power variation, you know, it really comes down to whether or not the variation is considered administrative or dispositive in nature.
Yeah.
Changing a liability clause, you know, I have to say I would like to research that particular point further before taking a position. You know, I think that if you ask me to take a view now, I would say that arguably it may not be in line with the settlor's intentions at the at the onset of trust. If there was going to be a limitation of liability, it should have been done then. So that's my preliminary view without further research.
It's a tricky one. Unham, what do you say on that? So that we determine that the settlor actually has a role to play, and quite an important role to play with respect to the trust investments, and could potentially have some liabilities as well. And then there's a question on, should we just vary the trust? Should we just give him protections that we enjoy as a trustee?
On the assumption that there are other beneficiaries and the settlor is not the sole beneficiary,
yeah,
I would take the conservative approach. I agree with Vigna. Subject to further research, I would be reluctant to put in a written opinion that you can vary it, because it is potentially detrimental to the beneficiaries. So the practical solution would be, if this is a revocable trust, you may have to consider revoking it and setting up a new trust with the proper language from day one.
Lin Chuan, what say you on this point? Lin Chuan, can you hear us?
Yeah. I mean, I think there's certainly a concern with, you know, all variation powers, that they have to be exercised in the interest of the beneficiary, right? And for proper purpose and so on. So, you know, if you added a limitation of liability, you have to explain why, you know. But perhaps, you know, if I could go back to what I said a little earlier about, you know, whether it is a question of defining the standard of, you know, the standard of care. You know, so if you sort of said, you know, I shall act in good faith, and it could be argued that, you know, the trustee decides that that's actually, you know, helpful to the, you know, to the settlor, you know, in not making him over conservative, because, you know, one of the issues with investments, you can take too much risk, but you can also take too little risk. So, you know, maybe he says, you know, if we set the liability correctly, then, you know, the correct balance of risk induces the behaviors that we want, right? And that's the justification for limitation clauses in general. So you have to be careful, but one way of thinking about it might be what I suggested.
Okay. I think the other question that will come up then is, given that if we analyze the settlor as having a position of standing in a fiduciary position, is the relationship between the settlor and the trustees. And so a question here would be trustee supervision of settlor reserve powers. Is a trustee exonerated when complying with a settlor investment direction? And looking at some of what Hong Kong has done with respect to this. So the first question I would ask us is, the interrelation between the trustee and the settlor, should the trustee be actually looking over its shoulder and making sure that the settlor is exercising his investment powers in a proper fashion? Or is it the case that the trustee can take an investment direction and just leave it at that? And I just supplement that with this. This is a copy of the provisions in the Hong Kong amended Trustee Act. And I've underlined the aspect where Hong Kong has said, if a power or function referred to in one has been reserved by the settlor, a trustee who acts in accordance with the exercise of the power or function is not in breach of trust, right? So that's effectively the Hong Kong position. The question for us here in Singapore is we don't have that provision. We don't have an express provision in the same way under our Trustee Act. So the question is it that the trustee should be supervising the settlor's exercise of their powers? Or is it that the trustee should be stand off and say, well, you're just a fiduciary, the beneficiaries can sue you directly if you get this wrong, and I'm not involved? What's the position that we take on this? Should the trustee supervise or not? And I think, Lin Chuan, if I could ask you to lead us off on this.
I think it depends. It's ultimately a question of construction, right? Of the trust deed and how the respective roles are divided between the investment advisor and the general trustee, right? Because this is a division of the administration of a trust. So where the line is drawn depends on the instrument. If you drafted your trust deed properly, you would make some express provision in it. Hong Kong has done it by statute, but if you haven't, then this is actually just something you would have to deal with. Assuming, for argument's sake, that you haven't, then it's still a question of construction. But it then perhaps becomes arguable that the trustee has the general duty of oversight, and he might have to, but much will turn on the wording. So difficult to draw abstract conclusion.
Victor, what do you think about this?
I think we have to look at two different cases, right? The first is in relation to reserved investment, settlor investment powers trust, right? I think in that situation, the likelihood that the courts would say there is a high-level supervisory power would be less. Yeah? But if it's not a reserved powers trust, the trustees have power investments, but it may appoint an investment advisor. I think that's when it becomes a bit more gray. But looking at how the Court of Final Appeal in Cheong Hong Lee and DBS ruled that there was no high-level supervisory duty based on the facts, I think that judgment was quite sound. What would also be relevant is on the facts, did the trustee actually exercise any sort of supervisory function? And if they did, then we may have an issue.
But the difficulty is generally the way in which trusts are drafted when we have settlor reserves is we don't try to import some of that language that we would expect when we have underlying companies. So it's what do we do in the absence of that sort of express provision not to be responsible for the actions of a fellow fiduciary? If we don't have it there, my sort of general common law view would be that the trustee, the primary obligation is to look out for the beneficiaries. And if they have a sister fiduciary who's misappropriating the funds or otherwise misallocating the funds, then they're going to be under some level of obligation, unless, of course, they are relieved of it either expressly or by statute. And the problem we have in Singapore is we don't have that. So it's left to us to free draft this problem. In many cases, the trustees won't contain those sorts of provisions. So in the absence of express provisions, and I agree with you, Victor, if there are express provisions, then that does start to draw the parameter. But in the absence of express provisions as to the interrelation between a trustee and the reserve power holder, what should be the default position as a matter of good practice for the trustees. And I'd ask Woon-Hum, what is a good practical step here? Because trustees will actually have this problem right now.
Okay, I'll try to answer that, but I'll break it up because in my mind, there are a few components or a few parts to this. So number one, if we were acting for the professional trustee and it is a reserve power trust, then we would actually pay attention to this and draft it into the trust deed to make it clear, right? And have the usual limitation, exclusion, provisions, and rely on the case law to protect the trustee. Second, if it's the settlor, the settlor has reserved powers of investment and the settlor is the sole beneficiary, I think it's actually a bit more straightforward. So the Zhang Hongli case was a case where the settlor was one of the four beneficiaries, the spouse and the two children were also, but he was basically calling the shots. So I think the courts perhaps were less sympathetic towards him, right? Now, if in those situations where the settlor is calling the shots, he's the sole beneficiary or he's the main key beneficiary and the rest were just like his spouse and children, then I think again, you could cut him some slack and give him some leeway. But again, because there are other beneficiaries, if his investment decisions are clearly out of whack, right? I agree that the trustee does not have a high-level supervisory power and you do not need to monitor him. It's not your job. You're not trained to do so. But if he's doing something clearly wrong and it affects in a detrimental manner to the other beneficiaries, I think the trustee do have to step in and do something. So I like to draw an analogy always, not a correct and entirely correct analogy, but I like to draw an analogy between the trustee and an independent director on a listed board. So you leave the day-to-day execution and the professional work to the trained and hired professionals, the executive directors and the CEO and the C-suites. But the ID is there to do a few things, including safeguarding the interests of the minority shareholders or looking after their interests. So in the same way, if the trustee smells something, feels that something is wrong, you should step in and do something about it.
Do you agree with that, Lin Chuan?
Yeah, by and large, yes.
Yeah. Tony, from your perspective, do you monitor the exercise of these powers? Do you?
Yes.
Yeah,
in the absence of any sort of controlled company provisions, we do monitor.
Right, and is it because you feel that there's some residual liability exposure if you don't?
Yes, we do, because I mean, I think Singapore kind of provides for the fact that the trust is not invalidated, but it doesn't actually say anything else with regards to, in the same way that that Hong Kong does. Right. So it doesn't actually cover any point on the oversight, in that respect. So we do.
Okay.
Even at a point sometimes when there is a controlled company sort of provisions, we still generally do, because we find that actually interacts quite well with the settler.
Right. Okay.